Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is an implicit bias program that looks at our intellectual property landscape through the prism of the implicit bias issues we must now address in our continuing education programs. We ask, do our copyright, trademark, and patents have implicit and systemic bias issues that we need to address? We will look at a variety of copyright, patent, and trademark issues then through the lens of implicit bias to do a dive into these questions that surround our intellectual property laws. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law, where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land, in our famed Yellowstone, that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and let's get going in our fascinating, and I hope eye-opening, or at least eye-pondering if that is such a phrase, exploration of how implicit bias may exist or be exacerbated within the core of our copyright, patent, and trademark laws. So let's get going with an overview of today's program. We are focusing on implicit bias, of course, but we will also talk about explicit bias and confirmation bias too, so that you can juxtapose this issue against well-known issues that we have long dealt with as lawyers in the legal profession. We will look at a fascinating case form, the 1970s, and see how the majority and dissent, just in language, can alter the entire characterization of humans in a terrible situation. And use this as an example of bias that creeps in implicitly in writing as part of the advocacy process that we, of course, have to be alert to, offensively and defensively. Thus, we will do a module on the implicit bias standards and how it works as an educational requirement. Then we will turn to our intellectual property module, where we will look at copyright, patent, and trademark through the prism of implicit bias. Specifically with respect to copyright law, we will be looking at the issue of artificial intelligence and copyright, how artificial intelligence works and collides with copyright law principles, and whether the massive issues on the horizon about artificial intelligence learning on stores of data itself impounds certain kinds of implicit bias because of the historical stock material that artificial intelligence is learning on. This raises the question of the massive fair use defense that the artificial intelligence companies are using to learn on current materials, if lost, may lead to more implicit bias in the system than not. Incredibly fascinating issues, and an intersection in the law with implicit bias that needs deeper consideration by those adjudicating these massive fair use questions on the horizon. Then we will turn to patent law and take a look at whether there is implicit bias in patent law, both against female patent applicants, where you will see some staggering data on the difference between grant rates for patents between men and women inventors. And we will also look at implicit bias that may then get impounded into patent law by virtue of this, due to the highly discretionary tests for patentability that examiners and judges are allowed to use. Finally, we will look at trademark law, and there, as we consider implicit bias, we will look at the center of gravity for the Lanham Act and trademark cases in terms of how it revolves around the, quote, economic consumer, end quote. And we will ask whether this focus on a sterile, dehumanized consumer ends up creating implicit bias in the system because it strips out the humanity of actual people and citizens who are ostensibly being confused. Here, the implicit bias question gets to whether there is simply systemic bias in the way we create this archetype of a consumer, and whether that construct itself strips human agency that we all have in so many contexts that may be highly important to really test for confusion. And we will end with some tips and ideas to challenge us all in terms of figuring out where our implicit biases may exist and how to unravel them to be better advocates for our clients. Let's start with the regulatory overview of where this program even comes from. In 2020, the California legislature enacted a new business and profession code section that required the California State Bar to update our continuing education requirements so that we could receive training specifically on implicit bias, as well as looking at strategies to reduce bias and how the unintended bias may affect different areas, such as race, ethnicity, gender identity, sexual orientation, or any other characteristics that could undermine confidence in the legal system. Which gets us to portions of this program which definitely focus on systemic bias within our intellectual property constructs. And in 2021, the California State Bar increased the requirements for us in California at least to have 2 hours instead of 1. Many other states now are following suit. And so this program will serve those of you where you have this requirement, but also those of you who are just curious and interested in this issue. Here is what's really important, because I want to talk to you out of the gate about what this program is and what it is not. This is not a program with any kind of a political agenda focused on lecturing you or telling you that you are biased in some way, that you are a bad person, or that you are a good person. That is not the scope and content of these programs that we produce here. And in the Curious Lawyer series, we look to just give you the straight bottom line facts. So this is a legal requirement to address implicit bias. So we have to touch on issues, but we are doing this through a different prism. Our prism is a positive exploration of the various issues that may sit beneath implicit bias without any charge of negativity. And we do this in a way by focusing on the positive benefits we can receive as advocates to unpackaging where we may have implicit bias. That is an unconscious association between events or data that may lead to categorizations in certain ways that do not help us. This can actually harm us as advocates if we are engaged in this in a way that may damage our client, or other people may use this to their advantage against us without us being able to recognize it. The result is that actually, if we do a deep dive and double click on implicit bias, we can use it as a tool to become sharper advocates. Here we are taking the issues of systemic bias, and we're using our intellectual property laws to filter systemic bias and implicit bias through it. So it gives us a chance to have a fun recap of cool copyright, trademark, and patent law principles, which are always useful and interesting for us to learn, and then use them to explore some of the implicit bias ideas. The ultimate goal, of course, is for us to be better advocates and better lawyers. And this program then should give us some actionable steps that we can take to see where implicit bias may exist and how that could impact our decisions as lawyers for our clients. One form of implicit bias, of course, that we have long dealt with in the law and we think about regularly in terms of when we are arguing cases to juries or arguing about facts that we have developed in our case, is the idea of confirmation bias, and it's something that we've long known to watch out for. Be careful of. So let's take a quick look at that, because it's a good entry point to the broader implicit bias issues we will discuss. Let's start quickly with some definitions of both implicit and explicit bias. Implicit bias refers to thought processes that occur without us knowing that our process may create an association that may not be founded properly in fact or logic, and that can lead to embedded biases, attitudes or stereotypes that impact our interpretation of events and people, for example, and then impact our decision-making and behavior, often which occurs without our express conscious cognition of it. Some associations can lead to negative, unfounded biases, and some may lead to positive biases that don't make sense either. Either way, knowing how this happens can make us better advocates. Explicit bias, of course, is the explicit idea of being racist or sexist or charging some other bias that plays a major role in the legal space and in our careers as lawyers for many decades in terms of our anti-discrimination laws and equal protection challenges. This is an area of law that is familiar to most of us as lawyers, so we will do a quick stop here first, before we turn to some interesting judicial writing examples of how implicit bias plays out, where we will do a comparison of majority and dissent language contextualizing and describing events. First, let's look at confirmation bias. Confirmation bias is a form of implicit bias where we as decision makers may actively seek out and give more weight to certain evidence that confirms a particular hypothesis we may be operating under, and at the same time, it can ignore or undervalue evidence or facts that may disconfirm our hypothesis. This creates a self-reinforcing tendency to seek out information or view things in a way that confirms what we already believe. Confirmation bias, therefore, contributes to overconfidence in our beliefs, even when we may be faced with contrary evidence. Now, for us as lawyers, of course, this is a very important issue we have long been aware of because it can be our Achilles heel. If we are litigating a case and we are afflicted by confirmation bias, we can routinely err on the side of overstating the value of our case and understating the value of our opponent's case, which can lead to terrible results. This is why we as lawyers have long discussed this form of implicit bias, because it's so critical to us to properly value arguments in order to value cases, to find amicable resolutions that make sense without leading everyone into a trial that could be a disaster for everyone. We also, specifically if you are a litigator, look at it offensively regularly to see where it may be existing in our opponent's expert reports, and we are constantly checking to see if our experts have tripped over the same lines, ultimately because care about credibility and legitimacy of the methodology being used. So this is one great example of long-standing implicit bias that we have dealt with in the legal profession. Let's now turn to our example of implicit bias in legal writing. And here we are looking at a majority and dissent opinion on this slide. On the left is what the majority wrote, and on the right is what the dissenting judge wrote. This is a criminal case from the 1970s called Rusk versus State, and you can see the case at 43 Maryland Appellate 476. The basic fact pattern is as follows. A man was charged with rape of a woman, and the case goes up on appeal after his conviction. The appellate court reverses his conviction. The case is useful because it allows us to look at how the majority framed the evidence and how the dissent framed the evidence. And in that process, we can unpackage implicit bias. Indeed, perhaps even express bias. This is a particularly important example to look at, not just to shine a light on gender-related bias issues as they percolated through the judiciary in the 1970s and perhaps even today, but also to understand how the framing of facts and how stories are told is itself an exercise in advocacy, and may well be an exercise in the employment of bias. These are things that we need to watch out for. As you can see, I have used highlights on the left and right, ink and red. The ink language matches you, the majority, with the dissent in terms of the issue that they are describing. The same goes for the red. So let's start by looking at the ink in terms of how the majority describes the victim of the rape. They start out by stating that the prosecutrix was a 21-year-old mother of a 2-year-old who was separated but not divorced. She left her son with her mother and went to a high school reunion where she went bar hopping. Now that is a version of the facts that the majority adopted, and we can see in there already various implicit biases, from calling her the prosecutrix rather than the victim, or using her actual name, to the idea that she essentially dumped her kid with her mom and went bar hopping, which itself paints a picture of a particular kind of person. Now, when we look at the dissent, we see a different approach, which seeks to tell a different story with the use of language. And here we have the dissent, identifying her as a victim, and giving her a name, and identifying that she went to her reunion, the friend, and that she asked her mother to babysit her child, so that she could go to this reunion, because she was going to be home late period. Now that tells a different story to a bar hopping prosecute. Trix dropping her kid at her mom's house to go get drunk, obviously. And I think it's a good example of how the framing with language can tell very different stories. The highlighted red language that you can look at demonstrates the same disparity. And so the lesson I think here is both in terms of the implicit bias that leads a court to write in this way to begin with, as well as the importance of not being tricked by that and being aware of it. The dissent here essentially called out the majority on this, and for us as advocates, the important lesson is that our opposing counsel may be doing this to us, perhaps not in stark ways like this on brutal recriminations rape victims, but it can be on far more subtle, boring economic interests, but it can nonetheless be equally powerful and important, so we should be alert to it. This brings us to our first intellectual property segment, copyright law. Here we will look at the intersection of artificial intelligence and copyright, as we are literally in real time watching it unfold in the public sphere and in the courts, and we will look at how the artificial intelligence cases battling over the use of materials for machine learning to learn on are triggering some implicit bias issues. This will require us to walk through some existing cases real quick that exist, as well as understanding how AI learning is working, so that we can get to the bottom of implicit bias in copyright law, and if the fair use defense will mediate the issue well. Let's get going on some copyright fundamentals, which you need to contextualize and then understand the artificial intelligence issues we will be talking about. Let's start in the beginning. Copyright protects original works of expression that are fixed in a tangible medium. Those are dual requirements for copyright to then attach to the creative work. Let's take the very first requirement, known as originality. It simply means that the creation is original to the author. This is not a requirement of something that is new and novel and never before seen. It simply means that it is the original creation of the author at issue. The bar for originality is very low. It essentially means that there must be the most minimal creativity and copyright will attach. For example, if you are watching this and doodling a pretty cool doodle on a piece of paper, you are creating a copyrighted work in this moment. Why? Because it is an original work of expression made by you. And it is also being fixed and in a tangible medium, specifically the pen to paper. But before we get to the fixation requirement, let's talk a little bit more about how courts approach the originality requirement. Courts generally do not want to get involved in making any kind of artistic determination about the artistic merit of a creative work. This is a long-standing policy in copyright law, which goes back over a century to the Supreme Court. It is indeed a fundamental bedrock principle of copyright law today. The rationale for this rule was expressed long ago by the Supreme Court, when it indicated that courts will not wade into artistic determinations because they are not equipped, and will on one end deny protection to things that are artistic, and on the other end give protection to things that may not be sufficient. This is what Justice Holmes said at the turn of the last century in the early 1900s. Quote, "At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. It may be more than doubted, for instance, whether the etchings of Goya or the paintings of Manet would have been sure of protection when seen for the first time. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. Yet if they command the interest of any public, they have a commercial value. It would be bold to say that they have not an aesthetic and educational value, and the taste of any public is not to be treated with contempt." End quote. Another underlying theme is that, when it comes to creative works, very few things in the most abstract sense are truly new. Here is another quote from Justice Story, quote, "In truth, in literature, in science, and in art, there are, and can be, few, if any, things, which, in an abstract sense, are strictly new and original throughout. Every book in literature, science, and art borrows, and must necessarily borrow, and use much which was well known and used before." End quote. These are two fundamental pole stars that frame the originality inquiry. So yes, your doodle is being protected right now. This brings us back to the fixation requirement. The Copyright Code's language is that it must be fixed in a tangible medium, which is legal language that means it must be recorded in some permanent fashion. This means pen to paper, oil on canvas, typing on a keyboard into the memory of the computer, or molding a piece of clay into a sculpture. What it also means is that if you come up with a fantastic little love poem and hire one of those skywriting airplanes to put it in smoke in the air for your loved one, you have not fixed it any permanent form, at least in that fashion. And today there is no registration requirement to have a copyright. It exists at the moment of creation. But to sue for infringement, you do have to register. And registering before a work is infringed gets you access to powerful statutory damages remedies. Specifically, if your client timely registers, then they can get statutory damages of up to $150,000 for an infringement if it was done willfully. This is a powerful remedy that is divorced from actual market harm or damage, and so is a very powerful weapon that makes registering very valuable. So, as a practice pointer, it is good to advise your clients who are creating works to register the copyright upon creation or publication. This brings us to the question of what types of works fall within the realm of copyright. Copyright protects books and other writings, music, of course, which we will be talking about today, movies and films, photographs, artwork, software, and source code, even architectural works and clothing, designs, as well as pantomimes, choreographs, and plays. This is just an illustrative list and is not exhaustive. What it does not protect is ideas, and the line between ideas and expression is very important in copyright law. Copyright law protects a given expression, but not the underlying idea. In other words, when Einstein developed his special theory of relativity, the paper he wrote would be copyright protected. But the idea of E equals mc squared, or the idea of special relativity, would not be protected. Other people can write and discuss that theory. The question would be whether in so writing they actually copied his expression of that underlying set of ideas, or if they wrote their own original expression. This idea expression line is a critical fault line in copyright, and courts will inquire as to whether the work at issue is really expression or just an idea. This is because under the Copyright Code, specifically Section 102B, no quote idea, procedure, process, system, method of operation, concept, principle, or discovery, end quote, is subject to copyright protection. In other words, copyright law is not going to allow one to monopolize ideas, systems, or other discoveries. The idea sounds simple in articulation, but often in practice, it can be very thorny. Here is a great quick example of the line from a Ninth Circuit case involving a yoga practice. A plaintiff, Bikram Yoga, claimed a copyright in a series of 26 yoga steps and poses performed during the yoga workout. A defendant used the same, or a very similar set of the 26 steps in their yoga studio, called Evolution Yoga offering Hot Yoga. Plaintiff was unhappy and sued, claiming copyright infringement. The Ninth Circuit held that the 26-step sequence described in plaintiff's book was not protectable against others using and teaching it because it was a health-based sequence and process. And, at root, it failed the idea expression line because it was an idea that cannot find copyright protection. In other words, the yoga sequence was the idea at issue, not the expression of an idea. Thus, as with the Einstein example I gave you earlier, any copyright in Bikram's book did not extend to the actual sequence itself, because that was an idea and process or system. Copying his book's actual language and images could be unlawful, but copying the 26 poses in a yoga studio is not an act of infringement. This is an excellent and important case to illuminate the line between idea and expression that we have discussed. If you want to read the full case, which is fun and excellent for an overview of these issues, you can find it at From the Ninth Circuit in 2015, case number 13-55763. So now you understand what copyright is and how it works. Here's the point that we need as we drive towards the artificial intelligence question. Copyright exists across millions of pieces of content out in the world and now digitized on the internet. There are millions or hundreds of millions of songs and books and plays and writings. All of that material is extant stock knowledge that artificial intelligence machines are using to lean on. And copyright collides with that because the act of reproducing another person's work is an act that arguably violates the Copyright Act in terms of the exclusive rights. Specifically under Title 17, Section 106, the exclusive right to a copyright owner includes, among other things, the right to control the reproduction of that work. So, for example, my book is available on the internet to purchase and download on the internet via Amazon. But if someone downloads without paying, that would be an act of infringement, because they have reproduced my book in violation of the exclusive right that I possess. This is where we get to interesting questions now about AI machines, how they work, and what content is out in the digital world for them to learn on, which drives towards the implicit bias question we will assess. Let's talk briefly then about artificial intelligence and how it works. These are advanced computer learning systems with algorithms and human-based reinforcement learning on the back end that ultimately augments how the machine learns. The result of a super complicated process that we are trying to distill into a few sentences for you is a computer system that's able to complete tasks that would otherwise require cognition. I won't read this whole slide to you, but it's there for you and your slide deck to study in more detail if you want. The aspect of it that you need to understand is probably what you may well know just from watching legal press accounts of ChatGPT that has exploded onto the scene. This is a language model that uses machine learning techniques to create human-like text in various forms. It can do this because it has learned and built on a massive data set of content. Pause there real quick. You heard me say that it has learned on a massive data set of content. That is where we are getting to our copyright questions, because that content is, if you double click on it, other people's books and songs and writings and articles and the like. The result of this immensely complicated ChatGPT system is that you can pose questions to it and get answers which are not always identical because it is not hitting a database. It actually is in real time running a complicated process to figure out the answer. And new and like human beings will come up with slightly different answers each time. So if you have not used ChatGPT, here is a perfect example of something that ChatGPT can do because it has worked on data to learn. You can go into it and ask it to give you a good Scooby-Doo story about Scooby-Doo and the gang chasing some witches who stole some gold. What you will get is quite literally a short story that's got a plot to it, some dialogue, characterization of the characters, and it will involve tee-hee witches and some gold, and it will simply make up a story that you could tell your kids. Or you can ask it to write you a song that is evocative of the Beatles, and you will get a set of lyrics that really do sound and feel like they could have been written by the Beatles. Now, it is able to do this because it has learned on Beatles music, or in my Scooby-Doo example, it has learned on the canon of Scooby-Doo works that are out there and understands the characters and what generally happens in all the Scooby-Doo stories, and it creates a new Scooby-Doo story for you. And when you read that story, You feel like it could be an original Scooby-Doo work. All that learning has required a level of reproduction of the original underlying works in order to be evocative in the new machine artificial intelligence output. Now, of course, this has generated a series of existing lawsuits by content owners and creators against the artificial intelligence companies. For example, Getty has sued Stability AI in February 2023, hedging that Stability AI, which has artificial intelligence to create images, learned on Getty's massive database of millions and millions of images. That is an example of an artificial intelligence machine where you can go to it and say, "Give me a picture of mountains in a river and some horses," and make it feel like it would have been painted by Picasso, and you will get an output that fits what I just asked for. Another lawsuit is by the New York Times involving artificial intelligence machines learning on underlying works of their journalists. And you have no doubt heard about other significant lawsuits being brought by comedians or other content creators who are complaining that the artificial intelligence is able to do the same thing learning on their copyrighted works. The basic argument is that the artificial intelligence created works that come out, whether it's a comedy skit, a picture, or a Scooby-Doo story as I gave you, are derivative works from the training materials, and the exclusive right to create those derivative works belongs to the original author. Moreover, the immensely complicated way in which the derivative work was even created, whether it's derivative or maybe a completely new creation, is that it had to learn on the underlying works, and that may have required reproducing those works in a way that was done without permission. Specifically, at some point for me to create a new Scooby-Doo story, I have to reproduce all the existing Scooby-Doo stories period now. That would be an act of reproduction of the copyright holder's rights, as well as when you create the actual Scooby-Doo story that is a derivative work of another exclusive right to the copyright holder. But you could reproduce all of the Beatles' works and not create a new Beatles song that doesn't actually infringe, but it's something that feels or sounds like the Beatles, which may not even be a derivative work. But in order to do it, you would have reproduced in the first instance D works of the Beatles. The defense to all of this is that the artificial intelligence machines are engaged in fair use by learning. And so the act of reproducing for these purposes is not unlawful and should be protected activity. In other words, at a high level, if you are a really talented musician and you have listened to all of the Beatles' music, you can go out and create a song that is evocative of the Beatles. And so long as you are not using their musical composition or lyrics, it would not infringe even though it kind of feels like the Beatles. Here the same thing is occurring, the argument goes, but in order to do that, there is a technical reproduction that occurs along the way, which doesn't necessarily occur with human beings who don't do that or who have bought the music to begin with and learn on. I have here on the slide for you a link if you want to go and actually see the complaint to better understand the complexity of these questions. But you can see already where we are going when we start talking about the canon of material that artificial intelligence needs to learn on, because that itself is a stock of material, or may not contain biases in it that then reproduce in the output. And this brings us to the implicit bias question. Here are some quotes that we have from both the White House and from some New York Times journalists who have written articles on it. The root is that AI needs good data. And if the data is incomplete or itself biased, then AI, which is learning on that biased data set, will simply exacerbate the problems of the bias. This raises the question of what data set is being used when we are talking about artificial intelligence learning. And copyright law mediates this because there is a set of material that can unequivocally be used, but that material is very, very, very old. And there's another set of material that can be unequivocally used, but it turns out that set of material may have embedded gender biases in it. If that is the totality of what may be used by the artificial intelligence machines because of copyright law, then the question becomes whether the learning set that itself may have significant bias in it is simply reproduced by artificial intelligence to our disadvantage. So let's talk about what is open to artificial intelligence without running the risk of violating a reproduction right. One category of works are public domain works. But a public domain work is generally a work that is almost a century old, and so is reflective of what was published about a century ago or longer. And that may well introduce implicit bias into the learning machines if that is all copyright law allows machine learning to use. In other words, 100 years and more, all the books, for example, that were published were almost overwhelmingly written by white male authors. Female, minority, LGBTQ authors, for example, may not have been published at all. And because those authors were not published back then, the data set of public domain material perpetuates this implicit bias that existed in prior generations, if that is all AI is allowed to learn on. This, then, is an argument against the copyright reproduction, right, and in favor of fair use and copyright law, as it mediates this issue, so as to not have AI incorporate history's biases again today in the output. Another set of more modern materials that AI could conceivably use without risking copyright infringement would be Creative Commons open license works. The Creative Commons started around 2001 and is a nonprofit dedicated to allowing creators to share knowledge, make works accessible, and you can see the history of the Creative Commons at that link if you want to go look at it. Perhaps the best example that we're all familiar with is Wikipedia, which is a part of the whole Wikimedia world. But in any event, there are millions of websites that have tens of millions of contributors to the content, all of which is open to use by people, because it is an open license world. That, of course, may save our history bias issue from public domain works, but it introduces another potential bias into the equation. Academics and social scientists have studied the Wikimedia editors, and as of around 2011, less than 10% were women, and by 2018, 90% of contributors reported still as being male. You can read the articles there, but the bias is obvious because what this would mean is that we introduce into the stock of material that AI machines are able to learn on now a significant gender bias in terms of the writings and perspectives of those who have created works in the open licensed Creative Commons world. That too then creates a problem like our public domain problem in terms of not being a representative set of material to properly reflect new outputs. So will copyright law and fair use law create more implicit bias in our future computer artificial intelligence learning systems? This requires us to take a quick look at fair use to figure out what it is and how it works. And you can see there the 4 factors that Congress has codified for the fair use doctrine. Those 4 factors require courts to look at the purpose and character of the use, including whether the use is of a commercial nature or A's for nonprofit educational purposes. The second factor is the nature of the work itself, and the third is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And the fourth is the effect upon the market or value of the copyrighted work. These factors are fact-intensive, and one common line that runs through the case law is if the new work is genuinely transformative, that cuts heavily in favor of fair use. But as you can see from those factors, and just as thinking about our artificial intelligence question today, and whether it should be allowed to learn on everything, you can see that arguments could be made on each factor going each way. The defense argument in these cases, fundamentally, is that the AI machines are transforming those original works by not just creating copies of them, or even similar new works, but instead by giving the AI machines the ability to create completely new transformative works, so that even if in the process there was a technical reproduction along the way, it should be permitted within fair use. The issue ultimately that we are left with here for our implicit bias program is whether copyright law itself, as applied to modern technologies, is going to impound implicit bias in the output, or whether it will take account of the implicit and even explicit bias that exists, and therefore give a more expansive sense of fair use to avoid impounding bias into the AI machines. Now we can turn from copyright law to patent law, and we can see some data here which will get at implicit bias that may exist in the patent system. You can see from our data that as of 2016, 21% of patents had female inventors, and 12% of all patent inventors were women. There's also data that has established that female inventor patent allowance rates are 5% less than male inventor allowance rates, and that female inventors received more office actions than male inventors. Office actions are responses by patent examiners telling you that there is a problem with your invention. We can also see that male patent examiners, the ones issuing those office actions, for example, outnumber female examiners by 3-to-1 period. It is a staggering differential. And if we backstop that with some implicit bias surveys that have been done, and you can see it here on our slide, in a massive survey pool of 500,000 people, 70% associate men with science and women with arts. This has been repeated in National Academy of Science experiments also. So the question we are left with for patent law is whether there is implicit bias in the patent structures that are creating these differentials in data from men and women, and whether it is the nature of patent law itself, given this data, and the headwinds that is perhaps allowing for implicit bias to occur, principally because, at least in theory, many patent law doctrines are highly subjective, which may become a petri dish for implicit bias to take root. Let's take a look at this on our next slide. So now let's take a look at an example of patent substantive law that, because examiners have wide discretion, and because of the nature of the law, it already arguably creates a situation whereby the patentability process itself is impounding these biases that we've talked about. Let's start with Section 101 of Title 35, which covers patents and the subject matter of patents. It says, quote, "Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent subject to the conditions and requirements of this title." End quote. In a huge case in 2014, the Supreme Court of the United States assessed and addressed abstract ideas and how abstract ideas are ineligible for patentability. This is the case of Alice, and let's take a look at it on the next slide briefly. The Alice case, and you can read it there, where I have the full citation for you on this slide, has a two-step process to figure out whether what you think is an inventive concept worthy of a patent is in fact really an abstract idea. Step 1 requires one to determine whether the claims are directed to ineligible concepts relating to, for example, judicial exceptions created about laws of nature or natural phenomenons or abstract ideas. If it turns out Step 1 is met, then under Step 2A, court has to consider the elements of each claim individually and in combination to figure out whether additional elements have transformed the nature of the claim from an abstract idea into something that is actually patent eligible. This requires a search for the inventive concept that allows the examiner or the court to make sure that this is more than just simply an abstract idea. This raises the question of what is an inventive concept versus what is an abstract idea, and how subjective and discretionary is this? On this next slide, we can look at some cases that have come down since Alice, which show that the broad discretion that exists within that malleable test that we just looked at creates massive uncertainty, fundamentally, but also perhaps drives towards bias, then being exacerbated because the petri dish itself is too flexible. Let's take a look at two cases. The first is Ultra Miracle versus Hulu, and this is from 2014 in the Federal Circuit, and you have the citation there. This was a patent that had claimed a method of distributing media over the internet in return for people watching ads. And the court held that it was simply an abstract idea, and it was not patentable, because offering media in return for ads itself was simply an idea. And it didn't really matter how many technical steps may be done in executing that patent claim, because at the end of the day, this was a quid pro quo of watching ads to get streaming media. Fair enough, you may say. But now, let's take a look at this case involving Hotels.com. And here we have a patent that had been issued on a method to retain website visitors on your company's website when they click a hyperlink so that they are not actually lost. This was held not to be an abstract idea, and so the patent was held to be valid. And this time it was held to be valid, unlike our Hulu case, because the invention overrides the routine and conventional sequence of events ordinarily triggered by the click of a hyperlink. The question this raises, however, is this all in the eye of the beholder? Because each of them ultimately are doing basic business things. One trading ads to watch streaming media, and the other employing technology, so that when people click hyperlinks, they don't lose their eyeballs on your website. At a high level, both seem very similar, but if this whole test is this discretionary and subjective, it means it falls into the hands of an examiner on the front end and maybe a judge on the back end, where different minds could very easily disagree on the exact same question. And if that is the case because of the subjective petri dish we're in, then that data we looked at in the beginning is being impounded in all of these decisions constantly, because the subjectivity itself allows bias to take root and issue or deny patents along those drastically different gender lines. We can take a look at what happened after the Supreme Court created this mushy subjective test in Alice, and there was a 31% increase in rejections in the first year and a half after Alice came down. There's a great U.S. Patent Trademark Office article that you can go look at that talks about this in more detail. But the key points for us here are that the uncertainty in rejections or grants of patents based on whether something is ineligible or eligible is a function of the broad interpretive latitude that the language of the Supreme Court actually gave in the case. The question for us in implicit bias, then, is when the law has this much uncertainty in it, are we exacerbating bias problems? Alice itself has created calls for reform with a pending Patent Eligibility Restoration Act to get rid of the judicial exceptions and to attempt to make the law and the line clearer, but that has not passed yet. So, as it stands, it is safe to say that when we are dealing with mushy subjective tests and staggering differentials in terms of how those tests are employed against gender lines, we are giving an outlet to implicit gender bias as opposed to stopping implicit gender bias. And this is where our patent substantive law, when it is discretionary and murky in language as opposed to bright-line legal rules, is probably creating systemic bias that perpetuates the implicit bias sitting beneath examiner decisions on inventors based on gender. Now we have addressed patent and copyright. This brings us to our third major area of intellectual property law, trademark law. Let's now talk about the Lanham Act and trademark law, and where we can see questions of systemic implicit bias, arguably, in trademark law. We need to start in the beginning, and that is Section 1125 of Title 15. Any person who on or in connection with any goods or services or any container for goods uses in commerce any word, term, name, symbol, or device, or a combination thereof, or a false designation of origin or false or misleading descriptions of fact, which are likely to cause confusion, mistake, or deceive as to the affiliation of such a person with another person, or in commercial advertising or promotion misrepresents the nature, characteristics, or qualities of another person's goods or services, can be liable in a civil action. That is the gist of it, even though I probably paraphrased it a bit, but you have the complete quotation there. We start here because we want to understand what trademark law is doing and what its purpose is in terms of protecting one person or company against another person or company. And we see here from 2019, the Supreme Court in the reference case held that trademark law has a, quote, specialized mission to help consumers identify goods and services they wish to purchase, as well as those they want to avoid, end quote. This focus on consumers as an archetype or a monolithic entity is at the core of our trademark laws. Here you see some other quotes from other cases talking about how many consumers are ignorant or inattentive and are bound to misunderstand things no matter how careful companies are. You see quotations here from the Seventh Circuit and from a Kansas case noting that the law protects the gullible and ignorant consumer as much as the careful and intelligent consumer. Those quotes are simply illustrative and you could find similar language in all the circuits and district courts of the country, so I just use these to illustrate the point. And the exact point is that the central focus is on this archetype that we call a consumer. And the law has a complicated test that it looks at to figure out if that consumer would likely be confused by one person's actions in commercial advertising against another person's actions. In other words, if you start selling shoes with the Nike swoosh, the law has a test to go figure out whether someone who sees the Nike swoosh on a pair of shoes made by you would be confused into thinking that they were source affiliated with Nike in fact. That is simply how trademarks work and how the confusion test works. Let's take a quick look on this next slide at the confusion test. Now, I'm not going to read this whole slide to you. This is for you to study later if you are interested. But I will talk to you about the gist of it, because this is the trademark law test across all the circuits to figure out confusion. The one I have used here is simply the Ninth Circuit jury instruction that is currently used, which comes from a seminal case in the Ninth Circuit. But all the circuits are almost identical on this test. This can be used as an illustrative one. The point for us in this implicit bias program is to look at some of these factors to understand where bias may creep into the trademark analysis that is being done all the time. And so the factors we look at are the strength of the plaintiff's mark, how the defendant used the mark, the similarity of the two marks, whether there's actual confusion, what the defendant's intent was, the marketing channels used, what is the degree of care that consumers in this area use, and factors like that. The central point here that I think I would focus you in on is actual confusion. And this is often held to be the most significant factor to figure out if there will be a proven likelihood of confusion. This is done by testing to figure out if consumer confusion is likely to exist in the marketplace, and assumptions are made about consumers by experts to figure out whether consumers would likely in fact be confused, and if indeed actual confusion has occurred. That can drive the idea that there is a likelihood of confusion in the behavior of the defendant. The other factor looked at is what degree of care do our archetypal consumers use in this area. In other words, if someone is buying chewing gum at a checkout stand in the grocery store where it costs $0.50 or $1, what degree of care do they use in making sure that that product's apparent trademark lines up with the brand? As opposed to, for example, someone who buys a Ferrari who is within the law less likely to be tricked into the source of the car not really being a Ferrari. Now, we can get at some of these questions by looking at this law review, which is well worth reading. It's from 8 Texas A&M Law Review 367, and it's entitled, "Is the Word Consumer Biasing Trademark Law?" So it's an article that I think is well worth reading. And we can look at it because it raises the question of whether this monolith archetype of a consumer that's often spoken of in nearly derogatory terms by courts, as we saw some of those quotes earlier. Question becoming whether we are impounding negative stereotypes or bias into the law, because we are able to talk about these issues with this archetypal depersonalized consumer. And here's the quote from the Law Review article. Perhaps the most salient objection to the term consumer is the dehumanization, reduction, and objectification of the buying public, which the term connotes. The consumer label evokes humans as objects instead of personifying them as real, living, breathing people. The role of the consumer is merely economic, passive, and recessive. End quote. Now, this verbiage, of course, is being used by all of us as lawyers, and our jury instructions, with our experts, and by courts because of the very nature of the structure of the law itself. And so this question we are now driving at is whether there is simply systemic implicit bias that adheres in our trademark laws that ends up leading to negative connotations as we analyze trademark questions simply because of our choice to use this dehumanized consumer as the benchmark, as opposed to an actual human being, a citizen, a person, for example. Here are some social psychology that sits beneath this implicit bias question as it relates to our trademark exploration. This is from a study called Cueing Consumerism from Northwestern University. And the researchers here found that being labeled a consumer, as opposed to a term like citizen or individual, can lead to negative stereotype, consistent characteristics, because of the linguistic biasing effects of the term consumer itself. And so the question we now confront is whether simply by treating the purchasing public as this dehumanized, objectified, and purely economic-oriented, quote, consumer, end quote, we are impounding some of these biases that our social psychologists find that come from the very word, which itself connotes only an economic, transactional-oriented entity. Here, of course, the question is raised not as one of express bias, but of a very, very deep implicit bias that was not even intentionally incorporated into the law, but simply exists by virtue of the choice principle revolving around a, quote, consumer, end quote, as opposed to talking about people or individuals. By archetype being the people who are being confused into this amorphous group of consumers, we allow biases that exist in the very meaning of the word consumer to affect who we are looking at and how we are thinking about how people respond to advertisements or logos or marks in ways that may then be less rational or less accurate than if we talked about the people being confused as being actual people. So there you have trademark law also to round out our intellectual property implicit bias analysis. One of the central issues that we have to address as we think about implicit bias is the continuing education mandate from the Business and Profession Code to actually think about actionable steps we can take to recognize and address implicit bias. And so here we have several steps that distill from today's program that we can all think about and use and incorporate into our practice to be better advocates ultimately and have less bias in our approach to lawyering. First, be aware of it. We should think consciously about the types of unconscious and implicit biases that may exist. The very act of going through this program helps you start thinking about these questions in a way that allows us to uncover where we may have implicit biases. This in turn lets us question ourselves and question the act of making snap judgments. We saw this perhaps early on in that example of the majority and dissenting judge in terms of just how they framed their story with the use of language, which we, of course, as lawyers are doing all day, every day. We can also actually take an implicit bias test, it's known as the IoT test, to delve deeper into this and see where you may have implicit biases or schemas of thinking that affect how you incorporate data and interpret it and analyze it and come up with an output. I actually have taken it and found it incredibly fascinating because it was eye-opening to see how you work through problems and think through issues and where there may be subconscious, implicit bias in your thinking. The tests are free, and you can take them notably through the Harvard University, which is where I have looked at it. I think it's well worth doing just to open your horizon to where you may be seeing these biases. And I have found that it's made me, I think, a better advocate being aware of it. The major issues that we see with intellectual property here are that we can see that implicit bias and systemic underlying bias can heavily creep into the law where we have these massively subjective discretionary tests that sit before administrative agencies in particular that we saw in the patent example, and perpetuate and further implicit bias in terms of patentability along gender lines. The answers here in terms of actionable steps are simple things. We can be aware of it first. Be aware of this as we talked to our judges and juries, and we can talk about this with our elected officials in terms of reforming patent law and the agency to strip out these types of biases. But for you as a practical pointer here today, major point I think is that bias can creep in anywhere. There is massive discretion in the law, and so being aware of that is critical, because depending upon what side of a case you were on, it may work to your advantage or disadvantage, but you should certainly be aware of it. And finally, I think one of the actionable steps that we can take to recognize and address implicit bias is to pay particular attention to our word choice in our legal writing, whether we are litigators writing briefs to courts, whether it's our word choice in front of juries, whether it's our word choice in front of judges on motions, or in front of agencies, or even for transactional lawyers, on word choices in transactional documents. Bias can creep into all these areas. And so cognizing it, understanding it, and then being aware of it is the first step to help us be clearer in our writing and avoid unnecessary bias. So this brings us to our conclusions today on implicit bias and intellectual property law. And let's do a quick recap of copyright, patent, and trademark law as it applied to our implicit bias program. On the copyright front, we saw that this massive new technology world we are entering with artificial intelligence, where the copyright exclusive reproduction right is colliding with fair use. Right in this technology realm is ultimately itself raising massive issues of implicit bias that should be considered by courts as they try to assess whether a use is fair use or not. Remember, if the technology is not allowed to learn on current, non-public domain material, and all it can learn on freely to develop this new technology public domain material, or perhaps Creative Commons material, then we unequivocally are impounding into the data set of the artificial intelligence machine's massive historical biases that existed simply by virtue of the fact that copyright law only allows public domain stuff, which is about 100 years old, to be used. Or in the case of even recent Creative Commons work, as we saw it is heavily oriented towards male writers as opposed to female writers. This then means that implicit bias in copyright law is at the intersection of the most cutting-edge copyright issues we are confronting as courts confront the battle between alleged violations of the reproduction right or appropriate fair use. We will see if courts take this into account as they look at the fair use questions. On the patent front, we saw that there is massive discretion to examiners on some of the most threshold fundamental patent questions. And because the law is highly subjective and discretionary, we saw that the risk for bias is profound. As we can see, the massive differences between grant rates on patents for male versus female inventors, and the massive difference in the number of examiners who are male to female also. One of the lessons we can take from this is anytime we have areas of the law that have massive discretion, it facilitates and enables implicit bias to creep into the decision maker's analysis period. Of course, the solutions become relatively simple there, and that is to have less subjective tests, and to also, of course, hire more women at the Patent and Trademark Office, where you take more steps to ensure that there is a neutral assessment of patent claims divorced from gender. Finally, we looked at the fascinating question of whether systemically there is bias in trademark law simply by virtue of its reliance on this abstract consumer that dehumanizes implicitly people in the citizenry, and perhaps may make finding actionable confusion even easier because we are talking about monolithic consumers as opposed to regular people. All of these implicit bias questions are fascinating. And again, I would end where I began, which is be cognizant of this in our writing and our analysis as lawyers. And it really does make us better advocates for our clients, which is our ultimate goal anyway. As always, if you have any questions, please reach out as I'm happy to talk.